He took it all stupid.
Okay, look. I don't know who you are, Life 3, but you're about to be kicked out of the courtroom.
I apologize, Judge Simpson.
Who are you?
Nathan Mason.
Got her. Okay, I don't want to ever hear that in my courtroom about anybody.
I apologize.
I don't know if that's going to be good enough, but I'll get you when you get to your case. Mute yourself. This case, people versus Jason Maples. What are we doing on this?
This was a show, except for a show cause that neither me or Schnauzer got the community corrections report, but he's also set to get a competency review. So I'm not sure we can do a show cause at this moment.
May I speak? Here's 60
Mr. Maples?
Yeah, I wrote 60 pages for my trial so far. I mean, that doesn't show that I'm competent. I don't know what will.
Before we even get into the substance of this case, take a breath and lock in, because this courtroom session is pure chaos from the opening second. What you're about to watch isn't just a routine docket call. It's a masterclass in how not to behave in court, especially on Zoom. We got a defendant who can't stay muted, can't keep her story straight, and somehow manages to confess to crimes that aren't even part of the case she's currently facing. Judges see a lot, but even seasoned courts have limits. And today, you'll see exactly where those limits are tested.
Your Honor, you can, if we can adjourn it 1 week or two,
When is his competency hearing?
In August. August
1st.
August 1st.
Or 4th, I'm sorry, probably. August 4th. Hold on one moment. Let me see what I wrote.
Is there any way you guys can do an exception for me to go to the law library? Because what you guys keep saying I'm not competent, I can't go to the law library and study the thing, because once I am proven competent, I'm going to represent myself. So in the meantime, I have lawyers that are not coming.
I have August the 11th as well, Your Honor.
All right. Set a show cause for August 11th, 2022, 9 a.m. I will also, I can't set a preliminary examination, so it's just a show cause that'll be set for that time at the same time as his competency hearing. Bond will continue. Thank you.
And just like that, we're already off the rails. This is a perfect example of why courtroom decor matters, especially in virtual court. Judges rely heavily on first impressions, and when the first thing they hear is a hot mic insult, patience evaporates instantly. Notice how the judge doesn't just correct the behavior. She flags it. That's important. Early disrespect can absolutely color how a judge views everything that follows, whether consciously or not. This isn't about personality. It's about control and credibility. If you can't follow basic instructions like muting your mic, the court immediately questions whether you can follow probation terms, court orders, or plea condition.
Court calls the case of the people versus Nathan Mason. That's the one.
Good afternoon, Your Honor. Alexander on behalf of the people.
Ready again, Judge. Torshell Feaster, Assistant Public Defender on behalf of Miss Mason. Miss Mason, please unmute and state your name for the record. Miss Mason, please unmute and state your name for the record.
Had a whole lot to say before.
Miss Mason, we're ready for court now. Would you please unmute and state your name for the record? I already got in trouble because I thought I was muted and I wasn't. And this guy, he was calling this guy name. He was sitting there looking crazy. I was like, he's looking off. Miss Mason, we got but I didn't know harm. Miss Mason, will you state your name? State your name for the record, please. Nathan Mason. Thank you, Judge.
Here's where things get unintentionally revealing. Writing a 60-page document doesn't prove legal competence. It often does the opposite. Courts don't measure competency by volume. They look for rational understanding of proceedings and the ability to assist in one's own defense. Over-explaining, over-filing, and flooding the court with paperwork is a classic red flag, especially in competency reviews. And when you add sovereign citizen-style arguments into the mix, courts become even more cautious. Judges have seen this pattern before. Endless filings, frivolous motions, and misuse of court resources. That's often why access to law libraries gets restricted, not as punishment, but as a response to abuse of the process.
Today's the date and time set for pretrial in this matter. I've spoken to Ms. Mason and to the prosecutor's office.
How'd that go? No, go ahead.
It's been rough, Judge. At this time, there are no offers on this file. If we could adjourn this matter, Your Honor, so we can hopefully get an offer, and if not, move it forward in another way to resolve it, Judge.
But can I talk to Judge? May I say something?
No. What do you not?
I was ordered to pay $180, but I don't have an income because I'm disabled now. So I was trying to explain to him that I talked to a court clerk at 14A District Court. I called the bus back up there and talked to her and told her my situation. She said I could make a payment plan, but they never sent me through the mail.
Ms. Mason?
This is the nightmare scenario for any public defender. Your client has been told not to speak, warned repeatedly, and still insists on explaining everything, often in ways that actively hurt their case. Courts don't operate on emotional storytelling. They operate on relevance and evidence. When a defendant starts volunteering information, especially about finances, prior cases, or unrelated conduct, it creates a record that prosecutors can use later. Judges can't unhear admissions, and once it's on the transcript, it exists forever. This is why attorneys interrupt, redirect, and sometimes outright shut their clients down. It's not disrespect, it's damage control. Every extra sentence here increases legal exposure, even if the defendant believes they're clarifying the situation.
Is that this file? Because if that's not this case...
Excuse me?
Is that on this file? Because if it's not on this case, Judge Simpson cannot do anything about that today.
Well, which case is this? It got to be the one I went to. It got to be the one that I already got ruled on because is it a case from that I had a bench warrant on? It was a warrant out for me on this case because I didn't pay the $180.
Okay, you never had a bench warrant on this one.
Me?
You never had a bench warrant on this one.
Is this the one where I had the crack pipe, the paraphernalia, and I got caught stealing from Myers?
No, this is the one where you were stealing from the store. Allegedly.
Right, from Myers, right?
Yep.
And there it is, the exact moment every defense attorney dreads. This is textbook self-incrimination. The court didn't ask about drug paraphernalia. The prosecutor didn't bring it up, yet the defendant introduces it herself, unprompted, on the record. Even when the judge clarifies that this case involves retail theft, the damage is already done. Courts rely heavily on transcripts, and while that statement may not be used in this case, it can absolutely influence future proceedings, probation considerations, or credibility assessments. Silence is often the strongest defense tool, and this moment perfectly illustrates why. When defendants talk themselves into trouble, the system doesn't have to work very hard at all.
From Myers or Home Depot? Okay, that's what I thought.
Yeah.
And that's the one that you ruled on for.
No, this is Myers. This is Meyer.
That's what I know.
You were stealing stuff.
That's the one that
allegedly. This has nothing to do with the crack pipe. That might have happened before or after. It has nothing to do with that. Well, I don't know that.
You gave me a 180-day rule, and you gave me a
Miss Mason?
$80.
Miss Mason, anything you say can be used against you.
What?
So would you please stop until we can try to get this matter resolved, and we can deal with all that stuff at a different time?
Okay. So what's, I don't want to go to no trial. What's going to take place now?
I was just going to adjourn it out so that everybody could talk to each other about it and get it. So I'm adjourning it to July 6th.
Thank you, Judge Simpson. Thank you, sir.
Thank you, defendants. The People versus Nathalie Mason.
Caitlin Kirby on behalf of the people.
Assistant Public Defender Melissa Kleeman on behalf of Miss Mason. And ma'am, can you unmute and state your name for the record, please?
We do not have her checked in.
I have had contact with her. I've asked the court for an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond $5,000, 10%. That warrant will issue.
Failure to appear is one of the fastest ways to turn a manageable case into a serious legal problem. Judges have packed dockets and limited time, and when a defendant doesn't answer a call, even briefly, it triggers automatic responses like bench warrants and bond forfeitures. What makes the situation especially tense is how thin the margin was. A dead phone battery, a few seconds of silence, and suddenly you're facing arrest. Virtual court gives flexibility, but it also removes excuses. Courts expect defendants to plan ahead, stay connected, and remain attentive. Even accidental absences can carry real consequences, as we see here.
Excuse me.
Okay. Hello. Who are you?
Hi, this is Natalie Mason, but my phone keeps messing up, Judge Simpson. So I just wonder, did you call my name yet? It keeps like going out and then coming back.
So you can't just interrupt the court. No, I didn't call your name.
Okay, so thank you.
We did call his name. Hold on.
Yes, we did call it, Your Honor.
Court recalls the case, People versus Nathan Mason. I will cancel the warrant.
Thank you, Jesus.
Caitlin Kirby on behalf of the people.
No, it's Judge, but go ahead. Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
And because you believe that you are indeed guilty of this offense?
I'm guilty.
April 17, 2021, at the location of 3825 Carpenter Road, Pittsfield Township, Washington County, State of Michigan, that being the Meyer store.
Believe it or not, this is one of the cleanest moments in the entire proceeding. The guilty plea colloquy is structured, controlled, and deliberate, and that's by design. Judges ask specific questions to ensure the plea is voluntary, informed, and factually supported. Notice how every element of the crime is confirmed. Location, intent, value of the merchandise, and lack of permission. This protects the plea from being overturned later. Despite everything that came before, the court finally gets what it needs: clarity. It's a reminder that even the most chaotic cases eventually funnel into rigid legal procedures that don't bend for personality or excuses.
I know.
What did you do?
Went in and concealed several items into some bags and attempted to exit the store. I was stopped by, loss prevention.
Okay.
Stopped me on my way out the door.
Okay, and the items that the store was open to the public at the time, wasn't it?
Yes.
Okay. These items that you took, these were items that were offered for sale by Meyer?
Yes, sir.
And you didn't have anybody's permission to take that property, did you?
No, sir.
And the total amount of the property that you took, was that in excess of $200?
I believe it was something. He said $400 and something dollars. I'm not sure.
So that would be more than 200, correct?
Yes, sir.
All right, counsel, have I complied with the court rule and would it be proper to the defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be August 10th, 2022, 9 a.m.
August 10th, 2022 at 9. Okay.
Yes, that's when you got to come back and see me, but you got to see probation before that.
Okay, yes, sir.
All right, thank you.
Thank you. So, Judge Simpson, I'm not going to have a warrant, am I?
Why, you want me to give you one?
At the end of the day, this case is a perfect snapshot of how courtroom behavior directly impacts outcomes. The judge maintained control, the legal process moved forward, and the defendant ultimately accepted responsibility for the theft charge. But the path there was far more complicated than it needed to be, largely because of unnecessary commentary, confusion, and missed moments of silence. Courts reward preparation, respect, and restraint. Everything else just adds risk